Let me begin by indicating that some of the opinions I will share here will not necessarily reflect that of my employer, in the sense that in the court system, matters are determined on the basis of evidence. Secondly, I have tweaked the topic to read collective licensing and the copyright law of Ghana. The outline of the presentation is that we will do some primers on copyright, touch on an overview of collective licensing, and then delve into some specific legal provisions that are relevant to our discussions today. We then talk about the responsibilities and to some extent rights of institutions who exploit copyright protected works, and end the presentation with some experiences from elsewhere. To begin with, copyright as an area of law, like all other IP rights or intellectual property rights, are private rights of authors and producers of protected works. As private rights of authors, and this is well captured by the TRIPS Agreement, which is the agreement on trade-related aspects of intellectual property rights. As private rights, it means that when you hold a property that is private to you, the responsibility to protect this property and monitor to ensure its enforcement primarily will lie on the owner or the right holder. That then tells us the challenge that confronts the private person who owns these knowledge-based assets. It means that they must have their eyes everywhere. And that is impossible because you are here and your ability to even move around to other jurisdictions to go and check who is using your work is a challenge. You try the visa, you may not get. Even when you get a visa, you may not know the dynamics of the country to know those who are using it for you to go and track them down. In the digital world, it's even worse. The server may be in Burkina Faso. The one downloading the product may be in Nigeria. And the user or the one who is actually viewing it may be in Ghana. So it's cross-jurisdictional, and for that reason, you can't work in isolation to monitor and police your work. And that is why there's a need for us to have what you call collective management organizations. So we'll do a bit about the need for these collective management organizations as justified in jurisprudence and in other authoritative documents. There's this Kenyan authority called the Cellulant Kenya Limited. And in law, if it's a civil matter, we say and, even though we say versus in criminal matters. The court in Kenya said the necessity of a collective copyright collecting society is imperative on account of the fact that such society has the expertise, number one, and the means of monitoring copyright users for purpose of assessing royalties that is required to be paid to the individual copyright owner. It will be impossible for an individual artist, in this case an author, to monitor the various media that exploit the copyrights of such artists or authors to determine the level of royalty that should be or ought to be paid. The cited dictum of the Kenyan court was cited with approval in the High Court decisions of Ghana Music Rights Organization and Scancom PLC. There's also another Ghana Music Rights Organization and Millicom and Airtel, and the Ghana Music Rights Organization versus Ghana Telecom Company Limited. These cases were efforts by a collective society to check how caller tunes, when you call someone on the phone, and then the music is playing at the background, do you want to download it for 20 cents or 20 pesos? Gumroad, when I was in private practice, we led them to court, and the court said that that is performance to the public, and for that reason, there should be royalty payments to the holders of the works. To make the work of a collective society meaningful, collaboration is essential, and that's why having IFRO and WIPO on board will help deepen your monitoring powers and your ability to enforce the rights of your members. Talking of WIPO, on their website, they have further elaborated on why you should have CMOs. He said that the creator of a work has the right to allow or to prohibit the use of his works. A playwright can consent to his work being performed on stage under certain agreed conditions. A writer can negotiate a contract with a publisher for the publication and distribution of a book. And a musician can agree to have performance recorded on compact disc, that's called CD. These examples illustrate how the owner of the rights can exercise their rights in person, but the individual management of rights is practically impossible for certain types of users because of the digital world that we are in now. It goes on to say that an author cannot contact every single radio or television station to negotiate licenses and remuneration for the use of his work. Conversely, it is not practicable or practical for a broadcasting organization to seek specific permissions from every author for the use of every copyrighted work. The impracticability of managing these activities individually, both for the owner and for the user, creates a need for collective management organizations. And that's what I indicated earlier, that the idea of having CMOs is emblematic of the saying that there is unity in strength. And that is why belonging to a CMO will assist you to get your rights vindicated. So, what do they do? What CMOs do, basically, is what the next slides will seek to explore. First is to actuate collective licensing arrangements between the right holders and the public. And by collective licensing, if you look at the Publishers Licensing Service of the UK, it's simply a way to manage the reuse of extras of published copyright materials, and it provides an efficient, cost-effective means of satisfying the two sides of the divide, the user and then the private right holder. Of course, the World Intellectual Property Organization has also expressed an opinion on it as to what collective licensing is about. So come back to Ghana. We have 3 major collective licensing organizations. And all that they are seeking to do is that they are managing the works of its members. And we have Gumroad, which is for musicians. We also have ASOC, which is for audiovisual rights. And we are here on the platform of CopyGhana, which represents reprographic rights bodies of persons. So the focus of the presentation will be on reprography, which is CopyGhana, and what they do. In terms of the laws that are available in Ghana, we mentioned 3 pieces of legislation and then the provisions in it will also be dealt with. The first is the Copyright Act 2005, Act 690. The non-lawyers, we normally number our laws from 1, 2, 3, At the time they passed 2005 Copyright Act, the number was 690. So now Parliament is on recess. The current Parliament, the numbering is around 1,200. So we'll continue to number till God knows when we may run out of numbers. The second one is a regulation that was passed pursuant to the Act. Anytime you have a substantive Act of Parliament, the law will empower the sector minister to pass what we call secondary legislation. And in this case, because pursuant to an Act of Parliament, it's called Legislative Instrument, LI. So in the lecture, I'll be talking of LI. This means that it's a subsidiary legislation to the main law. And the main law is Act 690. Recently, this amendment was done to the LI, and that is the Copyright Amendment Regulations 2023 LI 2469. So we'll be using these three provisions, or three legislation, to elaborate our points going forward. But what we must understand from the beginning here is that copyright protection, the rights, duties, obligations, whatever, and privileges that we have in the law are primarily statutory. It tells us that there's no common law protection for copyright in law. And there's an old decision of the British House of Lords, now the Supreme Court, called Donaldson and Beckett, which tells us that typical common law principles are not applicable when it comes to vindication of copyright issues. And I remember one case I did was for the family or the estate of Ephraim Mamo. You've heard of the famous Yen Ara Assassini Eyabo Dindin Mayen. When we were schooling, it was as if that is Ghana's Cree version of our national anthem. Very popular, because after God bless our homeland Ghana, we all chorus it together. Until you attend the good schools, you may not know the words. So, but you're able to say it when others are saying it, isn't it? Yeah. But General Assassin is so popular in the, what you call the SATO, those public schools, than even our national anthem. And the thinking was that it was as if it was a tale, a folk tale of the state, or called the folklore of the state. No, it's actually the private property of Ephraim Mamo, who passed, I think, 2002. So because the protection is the life of the author or the creator, and then 70 years after, it means that the work is still protected by copyright. And it was used by one of the operators, and then we sued on their behalf. Eventually, they realized that. But one of the defenses that was put up in the case was that if Ephraim Mamo's family had acquiesced or sat on their rights over the years for everyone to use the work, and they are not complaining. So you know what that means? In law, they are putting up a defense of what? Estoppel. Right? And our response to them was that estoppel is a common law principle which has no place in statutory-based areas of copyright. And we're successful. So, in terms of statutory provisions, to get a collective management organization set up, it must be grounded in law. And one is Section 49 of Act 690. It says that authors, producers, performers, and publishers may form collective administration societies for the promotion and protection of their interests. Right? So there's a procedure to go through. You form an entity, you apply to the regulator to license you, and there's been some rough edges as to whether you should have multiplicity of these organizations or they should be limited to some extent. At some point, I had an opportunity to advise that the market we have here is quite small, I mean relatively small, and therefore we should focus on subject-based collective management bodies. Other than that, you may have some being owned by my friend Adusei Japan, others being owned by Rexoma, some owned by Poku Adusei and his law and associates, and then others will be owned by Chinu Achibe and his people. So in terms of your ability to go to the market and say that the universities are using our works, they will say, which works are you talking about? We want to know those who belong to Poku, Adusei and Associates, those who belong to Chinua Achebe and the rest. And at that point, you know what the Bible says about multiple voices and how the Tower of Babel could not be constructed in time. It tells you that when you have multiple voices, it can defeat what you seek to achieve in law. When the body comes into being, it is bestowed with powers and rights. And Regulation 29, because it's an LI, we call the provisions regulations. If it's an act, we call it sections. A society which is approved may receive royalties and other monies which belongs to its members. They may take measures that it considers appropriate for the collection of royalties and any payments which members are due. Among the rights, they can also enforce the rights of its members, of course, by using the court system or even teaming out with other agencies of government to seize materials and cause arrest in accordance with the law. They can enter into contracts, review contracts in respect of works of its members, either acting alone or acting in concert with other institutions. They can seize work which infringe the rights of its members, cause the arrest of persons who infringe the rights of its members, and institute legal actions against persons who are violating the rights of its members. Fast forward, that organization or entity is also entrusted with the power to determine fees that is supposed to be levied. And if you look at the new amendment to the LI 2469, the insertion, which is Regulation 37A, says that a literary reproduction rights society, in this case CopyGhana, shall determine a fee in respect of photocopying and digital copying of works. It goes on. The law makes it even an offense to operate a CMO without the license of the Office of the Attorney General. And if you also study the regulations and the law itself, you see why you should even belong to a collective management organization as an author. A number of the source of the revenues that we have predominantly will not be when our publishers and authors set up a stand and they are just selling the books. No, because now almost over 70-80% of works are now going global through the digital world. It means that there will be cross-border trading in this product easily. So our law has made it a point that anytime you are importing devices into the country, equipment, devices that have the capability of being used to exploit copyrighted works, you pay a fee at the port of entry, and it's collected by SEPS, which is the revenue agency in charge of the ports. And the law fixed a percentage of CIF, 15% or 5% of CIF is charged depending on the device. And the amendment has even elaborated on the devices by expanding the scope. So we have smartphones and watches, digital cameras, video cameras, drones, smart TVs, photocopiers, scanners, printers. So when these are collected at the point of entry, they could be used to download your works. But you will not be able to do anything because the downloading takes place in people's rooms. Unlike the past where we had huge machinery of printing presses, now in your rooms, people can set up copiers that can do magic and copy materials for even further sale to others. So if you are not part of a collective management body, how can these revenues which are coming in be of use to you? Because the revenues will then be paid to the management organizations for onward distribution to its members. And you will then be as a loss. Also, among the sources of revenue to CMOs, we have their licensing regimes. And It's been ongoing. Now tertiary institutions are on board because in the arena of the tertiary institutions, a lot of usage of copyrighted works go on, and they have arrangements with them for them to sign on to and pay a fee, usage fee, call it royalty. It's a blanket royalty system whereby every student is made. Now currently the amount is 5 Ghana cedi per year. I mean, in terms of those who don't know how our currency works, that is like 30 cents to the dollar, paid per head, a student for a year, whole year. So that if you go to a photocopy area on a campus and then you are copying the work to go and do your private study, at least the law will allow CopyGhana to close its eyes to chasing students because there's a blanket royalty scheme in place. And we'll elaborate on some practical experiences when we are concluding the lecture. There could also be court monetary judgments, and anytime there is disagreement, that is the forum to go. And anytime they award whether damages, cost, compensation to these CMOs, they also get revenue out of it. We move to regulation of CMOs. Of course, we have a regulator in place, which is a state body called the Attorney General's Office and Ministry of Justice. And under that office, you have the Copyright Office, headed by an administrator responsible for administering copyright issues. So they license these CMOs with a cyclical period of about 5 years, renewable when you meet all their conditions. And that is how they operate. So if you start a society and you haven't gotten their license, it's an offense. When you are convicted summarily, you will be amenable to a fine or an imprisonment or both. As part of their regulations of collective management organizations, they check records of meetings, audited accounts, and other matters which will be required by the regulator before you can get your renewals done anytime you want to renew. There are some specific questions we want to respond to as part of this lecture. The first is, in respect of user institutions, and you know the institutions that normally will be using the materials you are seeing out there. We want to ask, does all forms of educational copying or uses fall under permitted uses? Or in some jurisdictions, they call it fair use, others call it fair dealing, right? And the answer is no. It is no because when you were studying law, it was difficult getting works of persons like Kluge. So we were just Xeroxing his law of succession and principles of equity, and then they will bind it nicely for you. It was going on. So imagine if Kluge had chased us in those years, but he would have gotten nothing though. We were as impecunious as a church mouse. So the right of reprography goes on in educational institutions. And these are rights which are vested in the right holders under Section 5 of Act 690, and also in international instruments, such as the Berne Convention. So if the right is vested in a private person, and then you are using it, how do you balance the two interests? One thing we want to stress is that copyright protection is not absolute. So it means that the law allows for some free riding by the public for free, but within what scope? And those are the possible exceptions we want to just elaborate on. So there's this straight step of determining what is even fair in the circumstance. It doesn't mean that if you are doing it for a private study, you take an entire work and then you photocopy it, whole book, and then you bind it and you are using it. No. Free riding must be done only in certain special cases, especially when there's access challenges. Free riding must not conflict with normal exploitation of the work, and free riding must not unreasonably prejudice the legitimate interest of authors. And in Section 19 of our Copyright Act, there's an exception for private copying for personal use, but it comes with some conditions. It means that the exploitation of the work should be for your personal use, number one. Second is that the user should be an individual. And the third is that the work should have been made public. Above all, the permissions that we have under Section 19 of our Act, which we call permitted uses, which are the exceptions, is that it should not extend to reproduction of the entire work. So when we did a study for on AC 2K, then the understanding was that if you were able to go up to 15%, it may be considered fair in practice. But if it gets to 50% of the entire work and 100% of the book, that can never be fair and can never be justified under copyright exceptions. And so it means that substantial xeroxing of someone's work may infringe the law. The next exception we want to stress on is library and archives exceptions. We know how certain works are rare to come by. And sometimes they've been used in the library over and over. When we were reading law, there was a text by Jandor and Griffiths called J and J. And those were the only materials you can read constitutional text in. And they were typewritten in font size 8. By the time you get there, someone would have taken an entire page to the room to go and read. He's removed it. So those kind of works were quite difficult to come by. What we do is that a library should be given an opportunity to preserve it by making a copy for further use. Otherwise, it runs out of the system and you will not get such vital pieces of work to use. However, it comes with conditions. It should be an isolated case, and it should be intended to preserve or replace a copy of which has been lost or rendered unusable, and even when there's no regime of collective licensing in place. So it means that if you know that there's a collective licensing or body dealing with such works, and you can approach them and get permission to use, that is the right thing to do. Otherwise, copying an entire work will not be an exemption. The next question we want to pose is whether there are laws specific to photocopying, and whether does banning photocopying exempt user institutions from obtaining collective licensing from CopyGhana. And once again, the answer is emphatic no. You see, the University of Ghana can announce that there should be no photocopying on our campus, right? But in reality, that will just be a mere rhetoric. In reality, it will happen. So just making that announcement will not actually exculpate the user institutions, because copying of a work goes beyond just taking a photocopy or setting it up and copying. Now there are various means by which work medium that it could be work could be stored, for which students may make use of it. Electronic sharing of them and all those are not things that your announcement of banning photocopying will actually be able to answer to, and they will still be going on in your institutions through online platforms, pen drive uses, and other webness platforms that the students may be studying under. It's also conceivable that an institution, an academic institution, may enter into digital licensing arrangements or agreements with some publishers. Of course, we have high online and other academic resources online resources that are used by these institutions. But that will only be able to take you to a point in terms of the bundle of rights that are in a particular piece of work. So it's impossible for institutions to have licensing arrangements with all the authors and say that we are covered. No. And therefore, dealing with a body that has assigned its rights to, members have assigned their rights to, will then save you from troubles going against the law. The next question, the third one that we'll pose is, can a user institution such as KNUST reject educational licensing because they are not liable for copying done by students? The answer once again is no. educational license offered by CopyGhana does not cover only students, because we have staff, lecturers, library staff who are also using it. So it's not only students who are actually using these materials. And if the students are not your employees, right, you still have some control over them. But what about your staff, your professors and library officials? So the means of dealing with this situation is to approach the licensing body and then have an arrangement so that each is then covered. One thing we must know is that in copyright law, even if the body that is, institution where the activity is going on is not directly undertaking it, that institution may be amenable to what you call contributory infringement of its players, right? So there's a principle of contributory infringement in copyright law. For instance, you get to any academic institution, the tertiary institutions, and you know that they have private photocopiers, right? They are that which are owned by the institutions themselves in the libraries, where students can go and then make copies. They are that of private persons. These private persons cannot come and then set up on your campuses and use your facilities such as your electricity and the rest if you don't have any say in what they do. And for that reason, you could be held liable for the acts and omissions of these operators on your campuses. Hence, the need to have a license from a CMO. The fourth question we want to pose is whether a user institution can reject an educational license because its fees are approved by Parliament. You know that for University of Ghana to increase its fees, it has to be approved by Parliament. Like all public sector institutions, under the financial management laws of the country, it must go through Parliament to have the fees approved. As I have already indicated, or as I did indicate at the beginning of this lecture, copyright is a private property right. And therefore, you can't say that Parliament is supposed to approve our fees, and for that reason, since they have not approved payment of copyright fees, you will not pay. No, it's someone's private property right you are exploiting on your campus, and therefore, whatever happens in Parliament, it's the same Parliament that enacted the law to bestow these rights on the private persons. So the law is no respecter of persons and must be adhered to, whether your fees are approved by Parliament or they are not approved by Parliament. Copyright is a private right. In concluding this lecture, I will share two experiences with you. I had the opportunity to study in Canada for my master's and PhD, and anytime you got your schedule of fees, you can check on any Western country's schedule of fees. You go in, these days they are all over. You look at it, then you see copyright fees on it. You are an international student, you are a local student, whether you use someone's work or not, whether you photocopied, because the uses are so many. And for the university to cover itself, you have it among your fee schedule, $15, $10 as copyright fees. That way, you are paying to cover others who may not even be using it at all. You are violating it, and then others are not doing it. And then the collective body will just say that at least they are paid something. That's why it's called a blanket royalty system that they operate under. It was the same with my McGill Law School. You find copyright fees on it, and you can't say that you won't pay. So it's incumbent on the leaders of our educational institutions who have equally been trained out there. You can't have a professor, any of the doctors in the universities who are leading the helm of affairs not know that they were paying copyright fees when they were there, and that kind of thing. And the final experience I want to share with you is from the case of CCH Canadian Limited versus the Law Society of Upper Canada. It's a 2004 Supreme Court of Canada decision. Those who have traveled to Toronto, they will say Toronto. They have one of the leading law schools called Osgood Hall Law School. It's at the University of York. And in Osgood, they have a library called the Great Library. So it's like before law schools became many in Ghana, the law library of the University of Ghana. It served as resource base for legal practitioners, resource base for judges, resource base for students, and even external researchers. So that's how the Great Library works. And because of its value and worth, the Law Society of Upper Canada, which is like Ghana's General Legal Council, they licensed lawyers, decided to mount stationary photocopiers in the library to aid with research. And then they posted by it the directives and how to use it. So you press here, you switch it on. It's like going to a filling station. You won't find normally outside human beings standing in the cold in Canada to give you fuel. No. They will be in the mat. You will just go and pull the pump and then serve yourself and go and pay. So lawyers were photocopying materials. They were using it for their work. Of course, there were guidelines on how to use it. And where you can't go beyond some percentage and all those set out in the guidelines. So CCH Canadian Limited, they are the producers of the law reports, Dominion law reports, the law reports of Ontario and all those. It's like Ghana having advanced publications dealing with publication of Supreme Court of Ghana law reports. Or Council for Law Reporting, publishing Ghana law reports. So that's how CCH Canadian is. It's a publisher of law reports. And the Law Society of Upper Canada is the one that has put a facility in place for this photocopying to take place. And they were sued by the publishers. The case traveled all the way to the Supreme Court of Canada. First, they had to even determine whether there is copyright in judgments of the court. Right? If you look at typical copyright law, there will be no copyright in judgment of a court. Right? But when someone sits down, like the late Bimpon Buta, who is very skilled in reducing judgments of courts, sometimes they will run into 150 pages of a judgment. And then he will distill it and get to call head notes, which saves a lot of law students. So you don't go and read the entire work, but you read the head notes, you will get an essence of all that the judge has said. This requires a lot of skill and judgment for you to produce such a report. And of course, the Supreme Court of Canada said, yes, there's copyright in it, and you can't just do it for free. What saved the Law Society was the guidelines that display that if you straddle beyond this point, then you're on the frolic of your own. You may be held culpable for copyright violations. It tells you that whatever is happening in your institution by students, your lecturers, researchers, library staff may be bordering on matters of copyright, and to safeguard each person, a collective management body such as CopyGhana takes only 5 cedis per head per student to save you that trouble. 5 cedis is just 30 cents, and for a whole year, if the volumes of violations that are going on the campuses could be addressed that way so that they are at peace, for them to get some money and reward for their members, it is actually fair. And from what I learned, this figure may be revised upwards, up to about maybe 10 cedis. I think that will still be less than $1 per head for a whole year. And if you don't want this, then what do you want? There's a pay way now per day. So I'll end my lecture by thanking CopyGhana for inviting me today. Thank you.